Ladies and gentlemen, welcome to the Setzler Subcommittee of Judiciary Non-Civil. We're going to go ahead and get started here. Appreciate your indulgence to have an afternoon meeting on the last day of session for the week. I think it's important that we be able to do business like this. Here we are. There we go. Representative, how are you? Appreciate you coming. I made the joke earlier that when Leader Trammell was a member of the subcommittee, when he was present, our intellectual quorum was present. That's largely been the case the last 2 years. I appreciate Representative McLaurin joining us. We're going to take up House Bill 141 first. I did speak to Representative Gaines about this very, very briefly, but we've got a sign-up list. Is anyone here that's not signed up for 141 that wants to be heard on 141? Okay. So with that, Chair recognizes Representative Gaines to present House Bill 141. We're working off of LC 412801 as initially introduced, correct? You got the floor.
Well, thank you, Mr. Chairman. And I'll be really brief. Jay Neal and his team with the Criminal Justice Coordinating Council are here, and we'll let them maybe get into some of the more specifics. But this legislation is an agency bill that relates to the Crime Victims Compensation Program, which reimburses victims of violent crime for financial expenses as a result of their victimization. And that program allows reimbursements up to $25,000 for medical, counseling, funeral, crime scene sanitation expenses, as well as lost wages and loss of support. On average, it's $20 million in claim payouts that are provided to more than 18,000 victims and their families each year. But over the last few years, there have been declining revenues through that program. It's supported by state probation, parole fines, and fees, and then an annual grant that makes up that funding. But there has been a loss of funding in recent years and an increase in expenses. This legislation will help us address that and saving a projected $2 million per year with the program, but also, most importantly, in my opinion, it'll help victims of crime and in a way to ensure that medical expenses are considered payment in full using the workers' compensation fee schedule. And this is pretty standard in other states as well. And so that's basically what this legislation does. Right now, the program is paying all medical expenses on behalf of crime victims at cost, which has, as we said a minute ago, adverse effects on the program, but more importantly on the victims, because non-insured claimants are limited in their ability to pay medical expenses billed at cost. So, an interesting statistic: 78% of all victims of the compensation claims were non-insured claimants in the last fiscal year. So I feel like it's a good bill to support the program and to help victims of violent crime. And so I don't know if the agency folks have any additional information they'd like to provide, but that's essentially what the bill does.
Okay. Being a subcommittee, we can be a little less formal perhaps in that. Director Neal, do you want to come and speak to this at all, or love to get some? I do have a couple of questions that may be a little more technical in nature, as the members might, but when you're here, you're subject to being called on. So welcome back.
Thank you, Mr. Chairman. It's good to be here. And I haven't had the opportunity, I don't think, to be in front of one of your subcommittees from this side. So it is good to be with you today. Representative Gaines highlighted well for you what this bill does. I will mention a couple things that I think give it a little bit better picture of what it is that we're trying to do with this. If someone comes to us with a medical bill that is $15,000 or more, obviously that caps at $15,000 for the medical. Our cap overall per victimization is $25,000. So if you have someone comes, for example, that has a $20,000 medical bill, and I know you're one that likes scenarios, so let me give you a scenario to help you get started. A victim of violent crime, whether it's assault or rape or whatever the crime victim crime may be, if that victim comes with $20,000 medical bill. Maybe they also, as a result of their injury, they've got lost wages that we can pay up to $10,000 in lost wages. There are other losses that they have as well that we're able to pay. Once we pay that $15,000 medical, that leaves $10,000 left. If there's the $10,000 in lost wages and there are other expenses that have to pay, we now are at the place to where we don't have the funds to pay all of those, and we have to begin making decisions about how those payments are made. If that $20,000 bill was treated the way any other medical bill would be treated, we would not be seeing a $20,000 bill. If there's an insurance company that gets that bill, there's a rate, a negotiated rate. If it's Medicaid that's responsible, there's a negotiated rate. If it's workers' comp, there's a negotiated rate. We're paying right now full medical bill instead of a negotiated rate.
So you're paying manufacturer suggested retail price for medical services as opposed to a negotiated fee.
And I would submit that I think most providers expect that that's not going to be the case when they issue those bills in the first place. We are a payer of last resort. So if that individual had health insurance, or if they were under Medicare, or if there's Medicaid, or there's some other type of payment, then that would have already taken care of a rate schedule. If there's anything left over, if it's a very large bill and there's anything left over, or there wouldn't be anything left over if it's Medicaid. But those that come to us are the ones that Representative Gaines talked about that don't have any of those coverages.
Sure.
So we're just asking that our medical bills be treated as industry standard. Most states already are doing this. And we would like to be able to do that as well. There's another thing that comes into play here, and Representative Gaines touched on it and said that this may be the most important. I would say to us, we feel like it may be the most important as well. When these victims come to us having suffered from violent crime, they already are under the trauma of the crime that they've experienced. That's one of the reasons we pay counseling, offer counseling through our Crime Victims Compensation Fund to help them deal with the trauma of their victimization. Imagine the trauma that they feel again months down the road when they find out that this $20,000 medical bill that they had, the Crime Victims Compensation Program had paid $15,000 of it, but now a medical provider has come after them for the remaining $5,000. Mm-hmm. We definitely don't want to see our victims face that kind of trauma, additional trauma. We see that from time to time. Our advocates will get a call from a victim that we've paid a medical expense on, and they're now being sought after to pay the remaining balance, and there's really nothing we can do about that. So a part of this bill not only provides that we pay at the workers' compensation fee schedule, but also if that provider accepts that payment from us, that provider is agreeing that is payment in full. And they will not be able to go after the victim for any outstanding balance above the $15,000.
Super. Got it. Questions from the members of the committee? Chair recognizes Representative McLaurin for a question.
Thanks, Mr. Chairman. Thanks for your testimony today. I like the bill a lot. I would love to make it even a little stronger. My concern in lines 18, 19, subsection 2, is that this payments shall be considered payment in full is actually not strong enough, because what that doesn't do, by my reading, is actually prohibit a provider from seeking reimbursement from a victim or a claimant. So, they might say, well, we've complied because internally on our books, we've considered that in full, but we're going to continue collections efforts. I mean, ultimately, when you talk about the trauma that a victim goes through, I've dealt with balance billing issues before. Part of the trauma is the fact that they are continuously pursued for payment. And so I think if you want to tighten that up and just make sure that there's actually a prohibition that providers not allowed to keep going after the victim, to me, that would be the provision you really need to make sure that person has peace of mind.
I caught that as I was reading this. That's one of the things I wanted to explore with you, Mr. Director, and then just kind of talk this through in the spirit of kind of subcommittee, a less formal, but substantive discussion. I mean, as you war game this out, what are we trying to accomplish? As I've said before, I'm just so fond of saying, if we decide very clearly what we want and what we don't want, and we can draw those lines and contours, the bill practically writes itself. Just want to make sure we're clear on exactly what we're trying to do. And I appreciate Representative McLaurin raising it. My guess is if we're paying workman's comp rates, and I don't know, I think Medicaid is plus or minus 84% in terms of what the reimbursements are. Do you know, not to put you on the spot, do you know about what workman's comp is? Is it?
I know that workers' comp pays at a higher rate than Medicare or Medicaid.
So it's gonna be higher than 84%.
Yes.
Okay. So if you think about this, if this is if you're payer of last resort, there's no other deep pockets, as it were, that's going to pay this.
Right.
What you've got is a provider that's looking at these costs, and they're looking at loss ratio. How much am I going to be able to get, and legal fees? So you would think something 84% or higher is going to be seen as a pretty beneficial. I mean, they'd rather take payments than try to fight for the whole bit, right? And I think that's where we are.
Mhm.
Is there a circumstance where we create incentives? And this isn't an opposition, it's just trying to understand it. Are there circumstances where we're going to create an incentive for them not to take payment from you and then try to pursue the whole payment? I mean, because again, if let's say there's $50,000 in legal expenses, you're capped at, maybe you paid $5,000 for something else. So we're talking about effectively a $20,000 cap. There's $50,000 of expenses. Are you intending to ask them to take $20,000 for the entire $50,000 of services? Are you saying we're going to pay $20,000 cap for $20,000 in services, and the other $30,000 you could go after the victim for, but you just can't go after the victim for the piece of the $20,000 that we paid for substantially, and you can't go in for the other 16%. What are you trying to accomplish?
We would like for them to not be able to go after the victim for any additional funds after they accept the payment for us of the maximum $15,000.
Okay.
That's what we would like to see. And quite frankly, when you look at the victims that are going to come to us at this point, where we're the payer of last resort, there's no other means for payment. These victims are not the type of individuals that are in a financial position to where a provider would reasonably be able to expect that by going after them, that they would be able to get in excess of the $15,000 that we're able to provide with the maximum
Sure.
medical cap.
I get it. That's why, in the spirit of seeking clarity first and then agreement and a consensus forward, because it does bring in people who didn't think it important to be in committee today. They're going to come to the table if we're saying, if someone is skulls cracked in and they spend, 2 weeks in an ICU at Grady, and there's $250,000 of expenses, and you got to serve them, but you're only going to get $15,000 for that. That may be good public policy, may or may not, but we need to know what we're doing and what we're saying by whatever we do.
Right.
So it's your belief that $15,000 of good faith through CJCC is enough to fairly cover what you normally see, in any outliers. That probably ought to get thrown in the bucket of uncompensated care, which we have other means to provided through provider fees and those kind of things to cover.
I think that's accurate. The scenario you're describing is clearly an outlier. In talking with our partner states around the country, we have found that similar language to this or similar statute to this has been effective in their states. We're basically looking to come to the industry standard of victims compensation programs.
Okay.
With what we're trying to do.
Okay.
And if you all see an area where you think you can perfect the language, I'm certainly not opposed to that.
Well, I'm going to invite Representative McLaurin to think through what some language might be, but I just want to make sure we're shooting for the same ends and we're clear about that.
Yep.
Representative McLaurin, you still have the floor. What is your thinking about this whole framework? What are you trying to accomplish, or what's in your you're thinking about this whole issue.
Well, to answer that question effectively, it might be good for me to clarify something and maybe put a slightly different frame on this. Am I right, since you are a payer of last resort, that essentially we're looking at medical debts that, were it not for the program, would essentially be uncollectible by medical providers? They'd be written off in many cases, correct?
I think that would be the rule. There's exceptions to every rule, but I think that would probably be the rule.
So in a lot of ways, we can think of the program as sort of doing two things, and correct me if this is a mischaracterization. First, it's actually goodwill by the state to compensate medical providers in cases where otherwise the debts would be totally uncollectible. And secondly, it essentially, especially with this balanced billing provision, would create a class of patient, i.e. victims who are covered by the program, who would be specially covered in terms of relief from medical debts. And that's a policy judgment by the state to treat victims of crime in that way. And I think that's appropriate. So I guess my thought would be, if I'm understanding that correctly, then it might be good to just, frankly, I mean, the part one speaks for itself. This subparagraph 2, you don't have to strike anything that's there. I think you could say a medical provider who is, billing for services from with respect to a victim or claimant covered by the program shall not pursue, right? And then put in some balanced billing language, just an extra line. And if the will of the committee is to create some sort of obvious punishment for that, or to, cross-reference some sort of other regulation. But I think the chairman's right. I mean, one thing, and I don't want to overly complicate this for you, but this is essentially a balanced billing provision. And maybe one of the reasons why there aren't a lot more people in the room right now is because you are a payer of last resort. So this is not going to significantly affect the business of a lot of medical providers. That being said, I think it would be good to be clear about what you're doing and make sure that that's tight, so that there's a clear prohibition as opposed to just language about how the accounting is done that, different providers might see fit to interpret in different ways.
Yeah. No, that's, I think you framed the issue, and that's the question. And I think if we frame it as you've defined it, then the challenge, I think that the question they'd be looking at is, let's take my outlier circumstance, which I would agree is an outlier, but call it $250,000 if bills, 100,000, let's call it $250,000. They'd look at this and say, okay, if we accept the 15,000, we forego the other 235,000. But I don't think this would prohibit them from saying, on a case-by-case basis, we're feeling frisky here. Yeah. We're not going to take the 15,000. We're going to go after the full 250. We think we can get it. As a payer of last resort, I think there's very, very few people they think they could actually get that from and hold up in court and actually get payment and all after all their efforts and expenses. I think as long as we don't take away their ability to say, it's not because I just think we've got to write good law. I think it'd be bad law to say, if you take payments from the program for any other victim the last 5 years, you have to accept it for other victims. I think that's not what you're saying.
Right. We're looking at a case-by-case per victim,
basis. Yeah.
per victimization.
Yeah. Yes. And I think at the end of the day, people could sit down and look at this and say, it's a tactical decision, right? And because those are outliers, it's probably not that. I mean, I don't know what the average or with the kind of what the range, the 75-25 percentile of payments is, or most of these things. Do you have any sense of that?
Aisha may have some sense on how often we get
big claims.
One of those big claims.
And I don't want to belabor the point. I'm just trying to understand what we're doing.
Sorry. Good afternoon, Mr. Chairman. Hey. The question was how often we get big claims for. Could you repeat, please?
For medical provider, when you're operating as the payer of last resort.
Yes. And
the victim's medical expenses have ballooned to something, well above 15,000. Is that's almost never infrequent? How would you frame that?
I would characterize that as frequent. We often get that. We pay the $15,000. Sometimes it's up to the victim to elect for us to pay up to the $15,000. So if they decide that, say we get a $200,000 bill, that they want us to pay $15,000 towards it, we will do that. Sometimes they say, no, don't pay that because I have other bills, other medical expenses. So yes, we do get that quite often. It's up to the victim whether or not we pay them.
What percentage would you say are the bills that exceed 30 or 40,000.
I would say probably about, and I'm guessing,
Mhm.
but based upon the numbers that I've seen, I would say maybe about 55, 60%.
Okay. And ask this question too, and to further complicate this, but I mean, we're just trying to, we'll converge on this. You know, it struck me recently, I went in for a outpatient knee surgery in December, just to go get my knee worked on from a meniscus issue. I had to pay 3 separate entities something, right? So, I mean, we may cap the payments to one entity. That we can only pay one entity for a medical circumstance. I mean, you'd think there'd be one entity that you pay that covers the facility and the doctor and the anesthesiologist, but I mean, it may be more complicated than that. It may be this entity is going to get paid in full, and this other entity is later to the table, so they get nothing. I mean, how do you work when you've got a hospital, you've got maybe a specialist that comes in, an anesthesiologist, you know, this whole layering of things, and there are different entities that you have duties to pay to. How does that get sorted out? Do you short pay each of these guys? Do you pay the first ones at the table? And how does that work in practice?
Again, we defer to the victim. So if they get a bill for an emergency room and they have to have dental services thereafter or physical therapy thereafter, if they go to a physician thereafter, they submit the bills to us that they want us to pay. It's totally at their discretion. So, I mean, if they can get one provider off of their back, right, and pay them, they probably would rather us pay a smaller bill and versus some substantially high bill
Yeah.
that they're going to be collectors are going to be calling them for anyway. So it's really up to their discretion.
And I asked that question to Representative McLaurin's underlying question is, what I read the language here, Director Neal saying is when you pay a provider for a bill, say their bill's $5,000, and say you're going to pay them 90 cents on the dollar, so you pay them $4,500. That $4,500 has to complete that obligation. They're paid in full. They're not going to go after the other $500 with the victim. That's what the language you have here says. I'm sympathetic to Representative McLaurin's question, but because you might have, you know, collectible, receivables from 10 different providers, from all these providers, entities from all these things, we may pay off, the first $15,000 in entities, but there could be other entities that have this $200,000 obligation who've received nothing from your system. So if we did what Representative McLaurin's suggesting, they've received nothing, they're not going to be prohibited from pursuing collection.
That's correct.
Because they've not taken a percentage in exchange for it, sort of as a waiver. So you pay the anesthesiologist, you pay the hospital, you pay the specialist, but there's these other charges. The $15,000 is exhausted on them. They write off $1,200 because that's not what's covered. But these other entities have never been paid anything. They're not going to relinquish their claim just because somebody else was paid.
Right.
So I just want to make sure we're understanding the kind of the ecosystem here. And I mean, what's your response to that, Representative?
Mr. Chairman, I think it depends on how much peace of mind the bill is trying to give. If the bill is trying to grant total peace of mind to a person who receives any medical services in relation to being a victim of a crime for which program compensates some of the costs, then obviously the prohibition on balance billing would have to be bigger. But if it's the chair's intention or the committee's will to limit the balance billing prohibition to just any provider that actually receives payment, and then again, that leaves more choice with the provider and the patient in terms of how to proceed, that's still a new protection. And I think that gets at the problem. It's just not a comprehensive balance billing protection as to these victims. I think that's just up to the committee.
And from our perspective, I think that's what we're going for. We're not looking to change the practices as far as how we handle when there's multiple bills. We're not looking at changing the practice. We're just looking at changing the amount of the bill that we pay by doing the fee schedule. And then once that payment's paid to a provider, that provider will no longer be able to go after the victim for the remaining balance.
So in essence, if you take the hypothetical of those 10 entities,
Mhm.
if any one of those 10 entities takes anything from your fund, they relinquish a claim on anything else. So they'd have to look at, if you say, hey, instead of, we're kind of out of money, we're going to pay you $2,000 for your your $5,000 bill. That's all we've got left. Take it or leave it. They'd have to make a tactical decision. Do we take it or do we leave it?
And Mr. Chairman, if you're the patient, I think the way it naturally would shake out under that framework is you would go with your top bill first. You would see if that worked. If the provider didn't want to do it, you go to the next bill. And you basically try to knock out the biggest bill you can by having the CJCC give the money, and then it freezes collection on the rest of that bill. So,
Or what I would do is if they're a well-informed victim, which they're not going to know this, is you pay the people off that are for-profit ugly and they're going to have a collections process. And you look at a nonprofit hospital that has an uncompensated care fund and say, well, let them take the hit. I mean, that's probably what someone would do if they were rational.
well, or you give everybody $1.
or spread it out. Right?
Yeah, right. I mean, and that's, I don't know that it's really up to us whether we're concerned about the game theory dynamics of this. I think at the end of the day, you're right that there's going to be a marketplace of decision makers and they can decide what they want to do. You know, if somebody's not going to write off $200,000 bill for $1 payment,
Right.
That's up to them.
Right. Exactly. I would agree with that. We're looking for the mechanism to put the fee schedule in place, and once you accept payment, then prevent them from going after the victim. Those are the two things that we're looking. We're not looking to change our practices. We're not looking to change those at all. And there's no way you ever get to the place to where you can, in something this complicated, figure out a way to address every potential complex situation that may come up. That's what the program deals with, that through our admin rules on a regular basis.
But again, we do want to give you the power you need to run an effective program. So if we need to give some more, provide some more horsepower to this, I think we're interested in doing that. We just have to understand what we're doing.
So I think allowing us to do the workers' compensation fee schedule, and then putting in the mandate to where once you receive that payment, once you accept that payment, you've received payment in full and no longer have the ability to go after the victim for the remainder.
Okay.
That's the two-step process that we're looking to put in place with this.
And Director, I like the language you have here. Payments made to and accepted by a medical provider. Medical provider can say, listen, I'm not taking 40 cents on the dollar. I want the whole thing, or
Right.
we're going to duke this out. Shall be considered payment in full for the charges with respect to board. So I like the language we have. If there's a better way to improve, if there's an improvement, I would love to hear feedback from members. Any other questions I do have a question, but any other questions from members of the committee about the bill?
Quickly, Director, would you be amenable to a one sentence addition to the end of the legislation that basically just makes totally clear that the balance billing in these cases is prohibited?
Yes, I'd be okay with that.
Okay.
What exactly does that mean?
Well, so there are state laws in various states prohibiting balance billing in certain medical contexts. And I don't have a encyclopedic knowledge of this, but there are statutes that sometimes go as far as granting private rights of action. And, there are all kinds of penalties potentially associated with going after people who can't pay with, again, it's called balance billing, because you're billing the balance of whatever insurance doesn't pay or whatever the, payment source doesn't offer. So my instinct here is, again, I'm not a pro at this, but I could see how somebody might say, well, yes, we've received payment. We consider it payment in full, but they might still send a bill to a victim and say, if we can try to collect on this, we will, because who knows what kind of internal accounting there is at a hospital or wherever that, well, payment in full might be, mean one thing. You could literally, I don't know, I'm just shooting from the hip here, but create a new accounting category that's payment in excess of full payment or something that you bill the victim for, and just do some internal accounting. I'm just making this up, but the idea would be that, if you want it to be a balance billing prohibition, you should just say that. It should say no medical provider who receives and accepts payment pursuant to this subsection shall or may send any sort of request for payment or bill for uncollected payments related to, however you want to define that. And then, like I said, if you want to put in some sort of I'm not here to make new crimes, as you know, Mr. Chairman, but if maybe a civil penalty or something like that, the idea would just be it's not just we're going to deem your accounting to be complete. It's you are not allowed to balance bill these patients, because that seems to be the intention of the sponsor and the committee. So,
Well, I think the language says that. And now, again, I'm certainly open to this discussion. Payments made to and accepted by a medical provider shall be considered payment in full for charge with respect to board victim and claimant. So, I mean, it's almost a deeming measure. It shall be considered. It is thereby deemed to be so.
yeah, that's a great argument, I think, but I'm not sure about it. Is my point.
And what language are you contemplating to clarify that?
What I just started with: no medical provider shall submit an invoice or request for payment for any uncollected sums pursuant to this I mean, something like that. And again, it's just a thought. If you think it does the trick and you're satisfied with it, that's great. But I'm saying if you want it to be a balanced billing prohibition, i.e. a prohibition against submitting a bill to the victim in excess of the amount paid by the program, that could be clear. That's my only observation.
I'm looking at this through my policy lens. I don't know. I think you want what you need in this, and not more or less. But
so we're comfortable with the language as is.
Yeah.
Based on the experiences in other states, we're comfortable with the language as is. We're not opposed. If you want to tighten it up a little bit, we're not opposed to that. What I don't want to do is get caught up in trying to perfect something that that may not need to be perfected more than we already have. But again, I'm not opposed to if you see an easy way to do that, I'm not opposed to that.
Yes, sir. Push your. Yes.
My live. Okay.
You got the floor.
Director Neal, I guess in reading this, maybe I got off in the weeds on this, but I kind of thought it was self-explanatory because that last word there on line 19, it says claimant. And I got to thinking, well, if we specified that as the provider, that might unnecessarily exempt a billing agency or whoever the hospital or the medical provider uses to collect on those medical bills. So the more I read it, the more I think I would be in favor of passing it as is. It seems pretty self-explanatory to me. And look, I practice law for a living, so, and I know Representative McLaurin does too. And, you know, it takes reading this a little bit over and over to, you know, really get the gist of it. So would you subscribe to that same theory that I just espoused?
I'm comfortable. I agree. I'm comfortable with the language as is. I do think this reaches the goal that we have as an agency.
Okay, I'm satisfied with that, Mr. Chairman.
Representative Smith, thank you. I do have one question myself to the agency or the author. Line 12, payments made by the board to medical service providers for compensation. Do you guys normally write the check to the provider? I mean, are you normally writing the check directly to the healthcare facility, or is there ever a circumstance in which it's covered by an individual and you pay them back? That probably doesn't happen much.
It almost always goes to the medical provider.
Okay.
If an individual has made a payment, and this sometimes happens, especially with some small bills that may come from a follow-up doctor visit, for example, sometimes they will have paid. So the compensation doesn't always go to the medical provider. Sometimes it will go to the claimant, to the victim.
Okay. So if the again, not to undo this, if the practice is they've got these bills piling up, they know you guys are able to pay, they're all too happy to have you write the check. So if that's what's happening, I don't want to undo this. I just want to make sure we're not constraining this in a way that if you have a substantial number of cases where you do have to have authority to pay the victim back, if you have that authority today and you don't need this bill to address that.
We have the authority to pay back the victim. If the victim had a church that raised, if the victim had a friend that made a payment for them, then that friend could file for that reimbursement as well. There are ways that we can repay people who made medical payments on behalf of someone.
Okay, so if someone had some that they went in for that, I'm just going to use something that there was a X-ray they had to get. Was it a broken bone or not? And let's say they paid $600 for the X-ray, and they paid that, or a friend paid that. Let's say the charge for the X-ray, instead of 600, you can negotiate it's 525, but they've paid 600. I read line 16 and 17, charges by the board in terms of their reasonable healthcare justifications for the deviation from such list as usual, customary reasonable charges. You guys could write, you could pay them back the full 600 as opposed if you want.
That's
so you got the flexibility you need. Okay, good. Any further questions? Anyone else here to speak on HB 141?
Thank you, Mr. Chairman.
And I sense a comfort level of the subcommittee with this. I would tell Representative McLaurin, although we try to perfect things in subcommittee, if there's something that we need to think about between now and full committee that the author and you all realize can make this better, we do have another bite at this apple technically. Is it so in the spirit of collaboration, do you have are you comfortable as a committee member that the bill collectors who are late to the table may get nothing, and bill collectors who are late to the table, or the bill collectors who are not collecting $1 through $15,000 but are trying to collect $50,000 through $100,000, are you comfortable that they could still pursue payment, or are you trying somehow to, through your act, through an amendment, wipe out all bill collectors after $15,000 is paid, even if they've got nothing?
No, Mr. Chairman, my intention was just to give effect to what the sponsors wanted, which is if it's going to be a balanced billing prohibition, that
put some more teeth in it.
Yes. And again, I'm happy to make a motion or make us, second that motion or do anything we're going to do today. It's just, that was I'm happy to be a book on the coffee table of your subcommittee that one may peruse at will. So,
I think the gentleman knows he's one of the classics in our committee if you're a book. So I wanted, in the spirit of deliberation, I want to make sure we've talked this through. We're not in if we need some more discussion, I want to make sure we have time to do it. So with that, to the author, any further discussion or context for us? Okay, what's the pleasure of the subcommittee?
Mr. Chairman, I move to pass as written.
Okay, got a movement of do pass and second. Any discussion? In that case, all those in favor of sending HB 141 LC 412801 forward with a do pass recommendation, signify by raising your right hand. It's done. Thank you.
Thank you, Mr. Chairman.
Appreciate your time.
Thank you.
Director Neal, great seeing you again.
Good seeing you, Mr. Chairman.
This is an easy bill for you. You're normally in here with 15-page whoppers that take more time than this.
Yeah, absolutely. Thank you. Y'all take care.
Yep. Okay, so we've got online people. Yeah, Director Neal, as a member of this body, brought a lot of, I think, very relevant and sometimes cutting-edge approaches to within the context of criminal justice reform. So it's good to see him back. Okay, up next is House Bill 258. Representative Saines, welcome to the subcommittee number 2.
Thank you, Mr. Chairman. Just to make sure, I know there was a sub proposed, but I had asked for that to be withdrawn. I'm operating on LC 480279. Is
Okay.
that in?
There is a substitute, but that's you're wanting to withdraw the substitute, not
Out
for the
of
underlying bill.
conference with stakeholders involved, they felt that the clarification in there wasn't necessary. There was a clarification to the code, not a change. But if I can operate off the substitute, but I think the simplest way is to operate on the
in
original.
subcommittee. It's up to the author, everyone you want to tee up. So
Sure. If folks have LC 480279, which is the original, that'd be preferable.
Okay.
So this bill seeks to address the case, the elements of State v. Williams 2020, where a court case, and I think it's I'm not an attorney, so I don't read a lot of case law, but I'm going to shortly summarize the elements of that case and to signify the importance of this modification. State v. Williams addressed a step grandfather, Kenneth William Howard, and as the perpetrator and the victim being referred to as EH, which is his 4-year-old granddaughter. The perpetrator did not admitted that what the granddaughter alleged, which quoting, Poppy touched my hoo-hoo and I touched his wee-wee, and quoting it, referring to William's finger feels good in and out. The grandfather did not deny this in court. His defense was that she would intentionally place his finger, that being the full-aged male, on her, the 4-year-old daughter. So he was charged with aggravated sexual battery. The lower court found him guilty, but because of instruction that aggravated sexual battery did not require the court to show proof because the victim was under the age of 16, the Court of Appeals reversed the decision because aggravated sexual battery does not have unlike child molestation, does not take away the state's requirement to show consent to show a lack of consent regardless the age of the victim. So with House Bill 258 LC 0279, and I'll go ahead and say most of the folks I've talked to are fine with lines 12 and 13, the changes made in section 1. In section 2, those deal with aggravated sodomy, child molestation, and aggravated child molestation. This really is there to parallel the language in the subsequent sections. It doesn't change the requirement to show. There's really it codifies what's already necessity, which is lack of consent isn't something the state has to show. However, in sections 3, particularly line 22 and 23, and section 4, line 27 and 28, when the alleged victim is under the age of 16, consent of the victim shall not be a defense to a prosecution under this code section. That is what's changing. That is the substantial policy implications of this bill, and is how we would address the notion in State v. Williams. There have been stakeholders who have been worried about, because battery and aggravated battery have two main elements of proving, for the sake of aggravated battery, proving penetration of a foreign object and proving a lack of consent. If you're taking a lack of consent, it leaves that one element. If a parent were to be helping the child with utilizing a tampon or bathing, is that parent then technically in violation of the code section? Both common law and sections of the code protect a parent's right to, above that, they actually protect a parent's right to give consent for the child for medical procedures and elements like that. That is kind of the gist of the bill. I know Robert is here with the Prosecuting Attorneys Council. I believe that the Defense Attorneys Association is represented online, and they probably both have.
Okay. I'm going to reach out. I'm going to tag Mr. Smith from PAC for a question. Before I do that, though, any questions initially from members of the committee for Representative Saines out the gate? Chair recognizes Representative Smith.
Thank you, Representative. Thank you, Mr. Chairman. Representative Saines, that was one concern that I had, was that innocent conduct, and I do realize there may be case law specifying that, but we may very well get in a situation where if we don't provide maybe even for an exception for innocent conduct, or try to address that, it may very well take some more case law coming down the pipe. And I think that's a risk we might be looking at with this. I like where you're going with it, I really do, and I know we'd spoken about it here before, but that was just one thing I want to point out that I see being potentially an issue going forward.
And I know the prosecuting attorneys council have more information on that innocent actors, the lack of necessity to add to that. But again, that is definitely policy wise not a disagreement between the intention of the bill. So if if the committee finds something to be necessary for clarification, that's definitely something I'm very unhostile to. So whatever the will is on that point. And I did forget to add, there is also protections for medical providers in different code sections, which I apologize, I don't have reference, but I was enlightened by PAC, which might be able to share the details of that enlightenment.
Thank you. Mr. Smith from PAC. Welcome back. We're at this again, aren't we? Yeah, come on up here. Yes, is Lalana Briones?
That's okay.
I'm Robert Smith. I'm General Counsel at the Prosecuting Attorney's Council, and with me is Lelaine Briones. Ms. Briones is our Deputy Director. She before she came to PAC, was a prosecutor specializing in child trauma and child sexual assaults. So between the two of us, hopefully we can try to answer most questions you have.
Where are we coming from before you're at PAC? Where exactly geographically?
Part of PAC, I was a member of the Crimes Against Children Unit in DeKalb, and I was also the executive assistant DA over Crimes Against Children in Clayton when Bob Keller was there, as well as when Tracy Van Lawson was there.
Okay. And forgive me, you may have been before this committee before, but the mask thing makes it very difficult for me to recognize people, so forgive me for that.
And Director Skandalakis sends his apologies. He has a family family issue this weekend that he's not here with us.
Appreciate you being here. I've got some questions. I think members of the committee might as well, but anything you wanted to present before we come to you with some questions?
Basically, this is an instance that the Supreme Court and the Court of Appeals have highlighted an issue, and this body has made it a statement and has issued some policies and passed some legislation about trying to protect child victims, trying to set out responsibilities and duties that people have to each other. And we're simply asking this body to recognize that the courts have asked you to weigh in on this issue, and we provided, and we're here to support and answer any questions you may have as to if this is something you wish to fix or not.
Sure. Any questions from members of the committee? Chair recognizes Representative McLaurin for a question.
Thanks, Mr. Chairman. Thanks, Mr. Smith. I would like to figure out exactly how this innocent actor's problem is going to get resolved. And I would start by asking you, in your opinion, if you add a provision like this bill does that says that showing of fact shall not be a defense, but you maintain the element without consent, right, in the actual definition of the crime, what is the interaction that those have? Because I think, the greatest end of concern, it's that you've removed the element to the crime, right? Could be one interpretation on this end. And I guess theoretically at the other end, you could say, well, no, it's still an element of the crime. It's just saying this won't be an affirmative defense. Is that your position over here?
That is my position, that basically the prosecutors still have to put forth evidence to get beyond a grand jury, to get the issue submitted to a trial jury, that the victim did not consent to the conduct. What this, and my thought is, and of course, none of us are in the position that we can ultimately interpret the law. We can only suggest what the words that we use are for legislative purposes. But the intent of these words is to prevent a defendant from going into court and having been charged with sexual battery or aggravated sexual battery to then say, no, I'm not guilty because the victim consented to the activity. The state still has to put forth evidence to show that there was no consent. But in this instance, the defendant is precluded from raising the affirmative defense.
Okay, and I don't mean to parse your words too carefully, but there seems to me to be a logical problem, which is, if I'm not wrong, you said 20 seconds ago or so, a defendant can't go into court and say there was consent. Now, I get that legally you're not going to plead an affirmative defense or say this is not an affirmative defense, but the way you characterize that, and this is what I would expect any defendant would do, if you were trying to take apart the prosecution's case, you're showing the absence of evidence for the elements, right, to do so. You can't, if you're the defense attorney, you say, I'm going to prove that you can't prove this case beyond a reasonable doubt. I'm going to do that by negating the elements of the crime. Well, on a logical standpoint, it feels to me like consent is a light switch. There either is consent or there's not. So if you're trying to prove that there was not, that the element of no consent is met, the only way you can do that is by proving consent, is my concern. And so here's my concern, that we'll talk about it. I mean, before trial, motions in limine, I'm a civil guy, so I don't do as much of this, but I would assume that prosecution would file a motion in limine that says, in advance of trial, the judge should bar the defendant from making any arguments about the presence of consent. And then the prosecution would cite to the new subsection F and say, that's clearly the law bars bring that issue up. And so then now my question is, are you in a situation where the prosecution is affirmatively trying to establish the element of no consent and the defendant's not allowed to rebut evidence of an element of the crime? That's the main problem I see emerging. Part
of the problem is that under the criminal code of Georgia, if a defendant raises an affirmative defense, basically, hey, the 12-year-old consented to the sexual activity that the 45-year-old man did to her, then the state has to provide evidence beyond a reasonable doubt defeating the affirmative defense. It's not a case of nothing being rebutted. It's simply that a defendant's able to say, the victim consented to the activity. And remember, we're not talking about adults. We're talking about children. We're talking about people 16, 15 years and younger. We're not talking. So in some instances, we're going to be dealing with children that can't necessarily verbalize. The victim in the Williams case, for instance, unable to verbalize and be able to use adult language about what consent and about sexual activity is. So we're talking about a defendant can still bring up fourth evidence. They can still tangentially attack the element, the state's proof as to without consent. They just can't say there's consent in this case, sit back down, and force the state to have to put forth positive evidence to defeat that claim. That's what this statute or this change does.
But you do already to establish the element of no consent, because that's an element of the crime, right?
We have to put that evidence.
You have to put forward affirmative evidence, right? So I guess my question is there really any legal significance to the lack of an affirmative defense per se? If it isn't, you're not allowed to make arguments at trial that there was consent. Are you saying that there is an opportunity to argue at trial that there is consent, but just not as an affirmative defense?
Not as an affirmative defense. You can do it through other means. Notice it's not saying that the defense can't put forth evidence. It's not limited. Does not limit the defendants. If the defendant chooses to put forth evidence, it doesn't prescribe that. All this simply prescribes is that if you have a victim below the age of 16, the defense is not able to say he or she consented to the
as an
activity.
Affirmative defense, but you can still negate the element of no consent under this bill as you're reading.
The same as you can negate a venue, identity, or any other element of the crime.
So, Mr. Chairman, if I may, I mean, it seems like we've got a logical problem that I'm concerned about, because what I understand to be the intention of the author is that for certain cases under 16 years old, it shouldn't matter whether there's consent or not. But if we split between an affirmative, we're parsing this legal distinction between an affirmative defense versus introducing proof at trial to negate an element, which are two different things. But if one of them allows you to introduce evidence of consent and the other one doesn't, I don't know that solves the author's problem. And it kind of speaks to the idea that if we really want a clear solution to this innocent person problem, which I think is a clearer issue with the proposal, it seems like we're going to have to define further, for the purposes of the crimes considered in section 3 and 4, that there's some sexual nature, that if we can add language that does that, and if PAC would consent to that, I think that's a cleaner solution to some of this, because that way we're not trying to figure out at a granular level what can defendants say or not say in court regarding the presence or absence of consent.
I can imagine Mr. Smith has concerns about the provability of that. Is that a concern?
That is one of the concerns. And don't forget that the two statutes are linked together, that, the definition of sexual battery goes into the specific areas of another person's body that are being touched without their consent. And then the aggravated battery is a step beyond that, but still retains all of those elements of the crime.
Right. And as the author alluded to, there, we all know there's situations where there's innocent reasons why technically that element is, if you take consent out of the equation, that the technical element about the touching is met in what we would consider to be innocent situations. And so we're trying to figure out how to criminalize the situations that aren't innocent. Consent is maybe one concept you could use, but the problem is if we're limiting how that can be used at trial, then it feels like we're going to have to add something to further clarify, like a concept that distinguishes between the innocent cases of touching and the non-innocent cases of touching.
One other thing also not to remember is that we're talking about innocent, and that's some of the things we had conversations about is medical examinations and those kinds of things. To get to the point that we're here where we're having this conversation, it's not simply that a father applying diaper rash cream or something like that to a child. That's not going to meet some of these thresholds. And then, because number one, to be able to get that, you're going to have a law enforcement officer investigate it, and then he or she's going to then have to go obtain a warrant from a magistrate judge for this crime. Then a prosecutor is going to have to convince either in the case of a felony, a grand jury, a majority of a grand jury, that this is probable cause and meets these standards. So there are several different checks. It's not simply where a prosecutor is going to, a road prosecutor is going to go out and grab a mother or father, some adult off the street and randomly haul them into court and make them answerable to this crime.
Well, and I think we know each other well enough now to know that I'm not going to be comforted by the idea that somebody who is in technical violation of a very serious criminal statute, for political or just kind of ordinary common sense reasons, we allege is not going to be dragged in, right? So I'm not going to be comfortable unless we have a clear legal distinction between the innocent cases and the non-innocent cases. And the problem is, especially if it comes to family abuse and some close call situations or allegedly close call or he said, she said, whatever, right? There are going to be cases potentially where a dad at bath time, gets charged with something like this. So I think it's got to be critically important to us that we have a clear legal rule that distinguishes between the two.
And I think then that becomes a bigger problem, because then the legislature is wanting to further exercise its oversight over law enforcement and judicial discretion, prosecutorial discretion. We can't, and this is one thing that this committee does a very fine job of doing, is trying to envision all of the different possible permutations of a situation. But we still have to, and you and I do have a philosophical dispute on that point, but I'd still believe that we have to trust state actors, to do their job and to do their job lawfully.
Well, I don't think anyone disagrees with that at some level. It's a threshold question. What's enough? What's not enough? I mean, would you agree that in 2020, 2021, our court now, you could debate our Supreme Court is maybe a little bit more textualist than it might have been in 2005?
I would say our Supreme Court is extremely textualist.
Okay.
And these are conversations that we've had where, the notion that, testimony is more than just simply, sworn when you raise your right hand in a court of law. Testimony is expressed to other things as well.
So to that point, as Representative McLaurin highlighted, as our court has become more textualist, something I actually approve of, but it makes us as legislators do our job. I mean, and you've heard me say this more times than you can probably count. I believe we have an obligation to do our job as legislators. If there's exemptions that need to be drawn, people are very nervous about exemptions. But that's what the legislative branch does is lawmakers. We're not as much self-criticism as we may or may not give ourselves, and certainly the public's highly critical of us. But we do have the duty not to be glad handers and baby kissers. We have the duty to come down here and sit in committee and put in details in statutes that decide criminality and that the courts can rely on. So I think we take that seriously. And this issue of the hygiene, parental hygiene, the kid, parents using washcloths to give their 4-year-old a bath, you talk about diaper rash cream, you talk about, tampons and female hygiene products. I mean, if we have a more textualist court, it seems we're invited to speak to that in ways we can't imagine every circumstance, but some that are clearly inside the boundary, I think we're invited to. I think we need to. I think we're, I'm not. I trust our prosecutors, but I trust our prosecutors to do their job in the context of law that we've written, not law that we've abdicated. So, I mean, I think there's a balance here that we need to think about. And I mean, I do want to ask that question. I mean, what kinds, we're going to open these code sections, what kinds of exemptions are we called to put in place? I do think Title 31 somewhere in there has it pretty well covered for medical practitioners. I don't know that I want to delve into Title 31. And maybe it's not in each one of these code sections. Maybe there's something else in Title 16, Chapter 6 that can be more broadly ranging in it. So I just say that parenthetically for the committee. I think I share some of Representative McLaurin's concerns.
Mr. Chairman, if I may try to make a distinction, and this is really at my peril because this might fall apart, but to me, it seems like there's a big difference between saying that we, on the one hand, have a criminal statute that obviously applies to plainly lawful behavior, and we just trust prosecutors not to prosecute what we like as lawful behavior. That's one type of trust that I'm not into. And then over here, on the other hand, we have a statute that might have some words that don't have a clearly drawn distinction directly in them. Like, for example, we have immoral or, improper in some of our criminal statutes, right? And that, those are ambiguous terms potentially, but we trust prosecutors to exercise judgment in determining how those words should be applied. That to me is a much more acceptable type of discretion. So for example, in the two code sections we're worried about in sections 3 and 4 of this bill, these crimes are called sexual battery. And the word sexual is ambiguous, but we're okay calling the crime sexual battery. The definition of the crime says a person commits the offense of sexual battery when, and I'm actually kind of amazed that nothing in the rest of that definition says sexual. The word sexual is not in there. I mean, to me, you could almost solve this problem by putting at the end of this subsection B, when he or she intentionally makes physical contact with the intimate parts of the body of another person in a sexual nature and without the consent of that person. And if you do that, you're even that move, although it's still vague to some extent, would give a bright line or some kind of line, right, by which you could distinguish between this bathtub issue and then the conduct that we're trying to criminalize. So is that something that you feel like you could do?
I think part of the problem is that then when we make that decision and do that limitation, we then have to look at how the other code sections interrelate into this, because it's what you just said, how does that impact child molestation? And that's one of the things that we then have to, we can make that, that's one of those things that, if you make that change, you then need to make sure we limit limit sexual battery to only be activity between adults, because that same conduct is now covered, is covered by child molestation. And then you end up with the disparity between the two as to, well, it's, both of them check off the same boxes in this instance. So which direction do we go in potentially?
Well, this is a case where the current definition is already broad enough to encompass conduct that's chargeable in other ways. So I don't necessarily see a problem with limiting the scope, even if only in that vague way I articulated, which is to attach sexual nature to it, such that this crime starts to look comparable to other defined crimes. I'm not concerned about narrowing the scope of this statute for that reason, right? If that is now, are you telling me there's a constitutional issue if the two, because you're saying they would, it'd be double jeopardy because they'd have the exact same underlying conduct, or is that the issue?
Not double jeopardy, but the idea is you need to punish it, but they need to be punished the same way. That basically, if you're going to say that
sentencing,
if you touch a child with the intent to gratify yourself sexually or the child sexually, that's child molestation, and that's punished differently than merely touching them in an inappropriate way.
Well, but isn't it true? And this starts to get into some heady stuff. But like if the elements of the crime are different, but the underlying conduct is chargeable in both ways, does that create a constitutional issue?
That does create a bit of an issue. So that's the idea is that if it's the same conduct can be punished by two different statutes and one statute has a lower penalty than the other penalty than the other one.
But that's not my question is if the elements of the statute, the two statutes are different,
Yes,
then there is no constitutional problem, right?
that is correct.
Okay. So what I'm proposing here is if we put in a sexual nature or some qualifier like that, and maybe you haven't looked at, obviously, because I'm just coming up with this now, but would we then need to ask whether the elements of that were identical to the elements of the other crimes? That's your concern, correct?
And let me ask this. I mean, it seems the language that and it may not be exactly the same, but the language with the intent to arouse or satisfy the sexual desires of either the child or the person, that language or very close approximation thereof, that is the qualifier that we use a lot in code, and that's the child molestation threshold. So, I mean, it seems like if that element can be proved up, it's child molestation. If it's not, it's sexual battery. For example, if you're patting a child you touch a child in a sensitive area, but you can't prove up this arousal, then that's when you leave child molestation and you enter the realm of sexual battery, right?
I would agree. Yes, Mr. Chairman. The problem is that, and as Representative McLaurin was just talking about, if you then put in, well, touched in an intimate area in a sexual way,
Let's say in a sexual nature,
it becomes this in between thing that I don't know that we have anywhere in law, and I don't know that it not that because it would be novel, it's a bad thing, but I think we've got these thresholds established for a reason. And we need to be thoughtful before we have to be very mindful of what we're doing if we do that.
And, because it gets back to, as you said, the words you pick, when you pick, and like, I'm not arguing in that, if that's the policy and that's your decision, but if you say when it touches in a sexual way, well, what does it mean to touch someone in a sexual way? Do you look to the guidance of another statute when it talks about for the gratification of another of the party?
And Mr. Chair, just to kind of refer to some of the concepts Mr. Smith has been talking about, that's when you trust prosecutors, you trust juries, because these are factual questions that are, I mean, like I said, there are other criminal statutes that say improper, immoral. Those are completely wide open words that could mean whatever the fact finder determines already, right?
And to quote Representative McLaurin, when we say vague things like sexual nature that are undefined, that leads us in the wrong direction.
Well, but we're in a tough spot, obviously, Mr. Chairman, because the issue we have is we've got a policy problem, which is we shouldn't be talking about consent under a certain age. And I think everybody feels pretty strongly about that. But we need to define these offenses appropriately. So I guess my question to the chair would be, can we think of collectively circumstances that the current wording of the statute covers that we want to criminalize, but that adding in a sexual nature would not cover? It would take away our ability to criminalize that conduct, and we think that's inappropriate. Because I don't know that there is a circumstance like that unless somebody can speak to it.
The only issue that we're going to get into, and I know the sponsor has something he wants to bring up as well, but the only thing I would point out is that one of the concerns that a lot of people have is this discussion about thought crimes. And if we're going to talk about someone touching someone in a sexual way, then part of the burden that's going to fall on the state is proving, well, what exactly was a sexual way, a sexual manner. And once again, if those are the words that the legislature chooses, those are the words that we will use. But that then becomes, well, how else can we quantify in a sexual way?
It maybe is difficult. I see a very similar problem with existing law in terms of intent to arouse. I mean, obviously we have mens rea issues in lots of crimes all the time, but I admit that in a sexual nature is somewhat vague. I am offering that just as a starting point for thinking about how categorically to differentiate between the innocent conduct and the not innocent conduct using a concept other than consent. That's the main thing I'm trying to figure out.
And I appreciate that. I think that's why we're having the discussion. I will tell you from in the sexual battery context, I have a little more comfort that a simple battery is you're making contact with a person's body that's not invited, that's not pursuant to consent. People know those sensitive parts. That's why as we've tried to explore these things, you want to make sure you're clear. I mean, it lists them here: genital area, anus, groin, inner thigh, buttocks, and so forth. Breast of female, but not the male. That's all defined in there. So I think adults generally understand the sense of touching people in certain places has a different nature than touching people in an uninvited way in other places, which is why it goes from misdemeanor and high and aggravated. It's the sexual battery levels. I mean, I'm comfortable that zone is defined. And because we've got this for the purposes of gratification, which is kind of the way Georgia Title 16 handles this sexual nature thing. I mean, it can be a very low level of gratification, but that of a sexual nature is handled through that clause we put on the end of things, which gets you up to child molestation. I mean, that's the framework I think we have in Georgia law. I'm comfortable with. I mean, I'm open to the thoughts of the committee, but I would say the question about what is this consent shall not be a defense under the age of 16. What does this mean relative to the element that's in there that's got to be proven? What impact does that have? And which gets back to my original question, which I'm not asking yet, is in Title 16 or in Title 16.6, we talk about consent. I was always of the mind that consent, age of consent is 16 in Georgia law, and below that it is criminal. Does that not apply across 16 Chapter 6, or is that on a code section by code section basis?
It's on a code section by code section basis, and that's why we were here. Because the Supreme Court and the Court of
As
Appeals
as a result of these cases, but prior to these cases, we 3 years ago we were flying under the assumption that it applied across Chapter 6, right?
Yes, sir, and that's part of the problem. And from the Williams case, that was the judge in that case gave an instruction based on the old law. The way we understood the law is that under 16, children can't consent to the sexual activity, so that in this case, the victim could not consent to what the defendant did to her. And the Supreme Court held that instruction was error. It was a mistake, and it should not have been done. But then they also pointed out that the evidence in the case was such that mistaken in jury instruction, the mistake of law, when the judge gave it to the jury, did not cause the conviction to happen.
So what are the jury instructions going to be? In a second, getting back to reference to McLaurin's underlying question, without, again, if you read 16.6-22.1, person commits the offense of sexual battery, he or she intentionally makes physical contact with intimate parts of the body of another person without the consent of that person, that relative to it shall not be a defense. What are the jury instructions going to be? How does a jury wrestle with that?
And to be honest, Mr. Chairman, I don't know the answer to that. The jury instructions are developed by the judges of the state. I can try to pattern one out or try to come up with the language that would be used, but I don't know what they would do.
And I say this, I will quote the public intellectual Dennis Prager, who says, let's first seek clarity, and then we can work on agreement. We need to be clear in what we're doing. We may or may not agree on the policy. There may be some policy differences, but I think we need to understand what we're doing if we're going to advance something. So that's kind of my baseline threshold. We need to understand what we're doing. And that's not a charge on it. It's not a salvo. We just need to flesh that out some, it would seem. But again, and there may be some other people who can speak to this that can further shed light on that. I'm not looking for folks to muddle this more. I really want people to help us hone in on that, because there may be a way that we can address what you're doing, that we can get great clarity on, and we can describe to other members. But there is tremendous trust when it makes it to the floor of the House of Representatives. There is great trust those 180 representatives have in what happens in subcommittee and full committee here. So there's at least got to be 10 people, 15, 20 people who are crystal clear on this. So
can I try one more attempt at clarifying some things?
I'd really rather recognize some other folks, but I'll give you
I understand. I appreciate it. I see us, and this may be my final word on this. I see us as being stuck between two hypotheticals, and they each have problems. The first one is the defendant's on the stand, and the direct exam is, was there consent, or can you describe what happened next? And the defendant testifies there was consent for this person under the age of 16. Then there's an objection, right? And then now we go one of two ways. Either that testimony is not allowed, in which case we've effectively completely removed the question of consent and whether the defendant can actually litigate that from the trial, in which case now we have this wide open possibility for prosecutors to charge what we potentially think is lawful conduct under these statutes, because we can't talk about consent, we have no other concept to differentiate, or the defendant is allowed to testify to consent, which sort of undermines the sponsor's purpose, because we're still litigating a question that, from a public policy perspective, we think that consent under the age of 16 shouldn't matter, right? So if we're going to accomplish the bill's purpose, I feel like we have to do so in a way that creates a new concept apart from consent, right? And to me, I mean, I will give a floor, I'm not like, but this is something I feel strongly about and I would speak against. And the argument I would make if we don't fix it is we have taken away a tool for distinguishing between lawful and unlawful conduct, and we haven't replaced it with anything meaningful. And we've made potentially bath time a felony for a lot of people, right?
Yeah, and there are some, and I can't quote the examples exactly, but there are some crimes that with force, that's a different standard than consent. So that's an example. I think what Representative McLaurin's saying is, there another threshold that's not synonymous with consent, that's relevant, that's more appropriate, that doesn't create this direct clash, that allows, I mean, because honestly, I mean, I think I think it's probative that all the facts come in that a jury hears with respect to something like a sexual battery. I think it's helpful for them to hear that, even if you recognize it's not a defense legally. You can still. So I mean, to me, I stray on the side of people finding out more information, but then having clear thresholds by which they make rulings. I know that confuses juries. That's just my personal bias in all this. And what I'm hearing you say is, we've not necessarily thought through all that conflict. So I just want to make sure we're stepping with confidence. Representative Smith.
Yes, I just wanted to, and thank you, Mr. Chairman. I just wanted to ask, how difficult would it be easier if, going back to the drawing board, just a suggestion, if y'all went back and we found a way to exempt innocent conduct, to not encompass this conduct? I know there's I guess the medical consent code section. I mean, you could add that. I had to go and look how we could do the parental code section. But I get what you're saying about the prosecutorial discretion. I mean, I worked for a prosecutor's office in law school and enjoyed it thoroughly. Y'all do good work. I mean, do you think that's just too rough of a hill to climb on this, or is it going to take away so much discretion that you wouldn't still be able to go after those evil actors that commit these kind of crimes?
I'm always up for any challenge. And Representative Saines, the sponsor of this bill, has been very good to work with, and I think that he also welcomes challenges. I don't want to speak for him, but I think he's also been busy writing over here, so he may have something he wants to share as well.
Right.
One minute, just simply a minute, because I don't think it addresses every single action, but I do think this might be a very low-hanging fruit to a very significant policy distinction. I'd be more than open. I think it addresses a lot of the innocent actor theory. If we were to replace line 22 and 23 and line 27 and 28, both parallel lines with those two elements with this, when the alleged victim is under the age of 16 and the conduct involved an act of a sexual nature, consent of the victim shall not be a defense. So it addresses that there's a lot of area that I think the committee's prudently addressed, that there's innocent actors that deal with children under the age of 16. But I do think the primary distinction of that innocent actor is a lack of sexual nature. And that would further restrict the exception for the prosecution to prove the consent element.
What other folks have we had signed up? I think there's some folks online. Is Miss okay, Miss Causey, or can you hear us?
And
Let me tee this up here, right there. Okay. Ms. Causey, can you hear us?
I can. Can you hear me?
I can hear,
I can
we can
hear
hear
you.
you okay. Let me turn this up.
Okay. You ready for us?
We sure are. Ms. Causey, welcome.
Thanks for having us today and allowing us to come virtually to join you. I'm joined by one of our members, Bernard Brody. Mr. Brody practices extensively in this area. Mr. Smith didn't mention it. He was involved in the litigation of the Williams case with an amicus brief he filed, and Mr. Brody represented Mr. Williams on appeal in that case. So his perspective is unique and specific to the issue at hand. I guess I might just quickly start where Representative Saines just ended. Unfortunately, I don't think just modifying those lines with the sexual nature aspect of the conduct helps us here, because neither sexual battery nor aggravated sexual battery ever requires conduct of a sexual nature. So to make if that's the way that the committee or those involved want to make a change here, it has to be to the elements of the crime, not to the sort of elements of a potential defense. But just to back up a little, just to take the bill on the whole, I just would want to let the committee know that respect to sections 1 and 2 seem to us, especially section 1, is simply codifying what we understand to be current case law. And so we don't have any concerns there. Section 2, there is no consent requirement for child molestation. So there is no consent defense today. So again, I mean, that language is not of concern to us, and not sure what it furthers, but it's certainly not going to hinder or cause trouble in those cases. But like the focus of the conversation here today, our main concern is about these innocent folks who would be wrapped up if the state was not required to prove a lack of consent. We certainly do. I appreciate what Mr. Smith has said with respect to his belief that they would not be relieved of that burden. I'm not convinced that this language ensures that. And that would be important to us, to be sure that they are not relieved of that burden, because it is important to distinguish between these innocent actor cases from those that are criminal. One of the things that's come up today, there's an undercurrent happening that maybe the committee's not aware of, and that is these crimes carry very disparate sentencing, very disparate punishments. And that is likely some of the motivation behind wanting to kind of ensure that, for instance, aggravated sexual battery remains, I'm gonna say easy to prove. Adding more elements to that crime will make it more difficult to prove. Aggravated sexual battery on a first offense carries either a life sentence in prison or a minimum 25 years with a life parole. I'm sorry, yeah, life parole supervision. And that's very different than the sentencing on a first child molestation, which is 5 to 20. Sexual battery is a misdemeanor. So there's an undercurrent here that I think we have to pay attention to. That in fact, in the Williams case, for instance, Mr. Williams, by the way, he remains now, after all these appeals, convicted of the offenses of child molestation and aggravated sexual battery. This is not a case where someone arguably got off the hook, or he's convicted of those charges, and he was convicted of 2 counts of child molestation as well as the aggravated battery that carried through the Williams decision. I would love to focus our remarks on any specific questions you all have. If you want to chase those down with us.
Yes, Ms. Causey, you've got, walk us through that if you would.
Bernard, would you like to just give it your perspective on the problems with these sections?
Yeah, so I think I think Mr. McLaurin really kind of, hit it on the head as far as what the issues were with this bill. And I think that the new proposal that we heard right there at the end, saying that a defendant cannot raise this defense if the act was of a sexual nature. I think that creates additional problems because now we have an issue of who determines that? Who determines whether the act was of a sexual nature? Is that something that the judge determines, or is that something that the jury determines? The jury determines it, well, then he has to raise the defense because there it is, we're at the trial. So I just think that there's a real problem with creating an additional element that only applies to certain people. I think the element has to be there in the statute for all offenses. And then there's uniformity, and then we know exactly what to expect. So I think that Mr. McLaurin's, I hope I'm pronouncing that right, his suggestion of modifying the statute itself, the act itself in the statute, and making it an act of sexual nature, or calling it a sexual act like we do in the sodomy statute, or calling it an act that is for the purpose of sexual gratification, like you do in the child molestation statute. Doing one of those things now modifies the statute in a way where we don't run into an issue of somebody who commits innocent conduct getting prosecuted, like the caregivers and nurses, the babysitters, and all them. The medical exception does not apply to anybody but licensed physicians, so that doesn't really have any broad effect of protecting anybody. So there is no other real protection for all of these other innocent actors. So the only way to do it is to modify the statute, the entire statute, and the acts that are encompassed under that statute, and to require that they be acts of a sexual nature or sexual acts. That way, those are issues for a jury. We all know now what is required to be proven by the state. There's no inconsistency between the elements of the offense, the burden of proof, and the defenses available to the defendant. And I think that's the simplest fix. And that's exactly what the court was saying in Watson and in Williams. They weren't saying that the problem was an absence of language regarding lack of consent. They were saying the problem was that the statutes don't require the act to be sexual. And that's what opened the floodgates to all of these innocent actors being swept up in it. And that's what caused them to rule the way they did in Watson and Williams. So the simple fix is to modify the statutes and require the acts to be sexual. Once that's done, there are no other issues. Once that's done, then you have the body of case law that already says that if it's a sexual act involving somebody under 16, then for the jury. That's a jury instruction that was the jury instruction that prompted the Watson and Williams cases. So you could add that additional language that is being proposed once you modify the language in the statute requiring the act to be sexual. But it's got to be the entire statute. It can't just be something that only applies to defendants with children under 16. It's got to just be an element of the offense that makes it sexual.
Okay, to the author or anybody you designate, so the contention here is that this consent issue is not really the thrust of these cases that needs to be addressed, that you're shooting at a target that's not the appropriate target, I think he's saying. What Mr. Brody is suggesting is that to address Williams, and then as much as that's affected by Watson, the real issue at hand is this need for this extra element. That this in the element being of a sexual nature, that is a different bill than you're bringing before us. What's your response to that? I mean, it's as you've studied these cases, and I would ask that to PAC as well. Want to make sure we've defined the problem adequately before we start to fix it.
PAC to end this, because I think they're going to be able to more wholesomely address it. But when I'm hearing let's modify the elements of the crime instead of restrict if you feel that discretion is uncomfortable to give to the prosecution, addressing the innocent, if it's truly about the innocent actor issue and potentially widening this net to where we're not talking about a step grandfather sexually victimizing a 4-year-old who's not able to verbalize, which is proven it is an issue in court. If we're truly trying to narrow this exception, and I'm sure there's 30 solutions to two problems. I think where we're at, the only thing from my perspective that is a sincere policy concern is widening the net where this is unintentionally, where the element of consent is unintentionally lifted off of innocent actors, is the substitute that we gave, where we are adding, if we are going to restrict the state's ability to have to prove one section, which is consent, we're adding that to the restriction of that exception of a sexual nature. I don't, again, I would lean on PAC, and I know Legislative Council isn't here, but I don't think it's in conflict with allowing us to make that exception more restrictive. But I know this is a legislative Friday, so I don't want to talk it. Would Mr. Smith, do you have anything to add to that or clarify?
Okay, I've got legislative counsel.
Okay.
They're not asking to speak, so they are available.
Oh, they're available. Okay, I got you. Well, I mean, again, I want to, there's, expanding exemptions. There's a whole lot of mental gymnastics you go through as you wrestle with these things. Can I address PAC? Right, and you can stand up where you are, Robert. I don't know if everyone can hear. The authors proposed a bill that I think is attempting to clarify this: the consent's not a defense under the age of 16. Do you believe, is it PAC's opinion that there are broader issues that need to be addressed legislatively arising out of Williams and Watson?
Mr. Chairman, I'm going to start off by just the Williams case. When it's certified, the Supreme Court certified its question. The first question the Supreme Court asked.
We do have people online. If you wouldn't mind coming over, that'd be great. Thank you.
The first question the Supreme Court asked all parties in the Williams case was, is the state required under OCGA 16622.2 to show lack of consent in order to prove an aggravated sexual battery against an alleged victim under the age of 16? So that's when I look at a case, I look at, what did the Supreme Court want to know as to what the main point of the case is about. There is always room for improvement on statutes. There's always room. And that's why this legislature comes back into session every year to see how we can improve, how we can fix. And I'm sorry for using the word we, because that's for you, how you can fix it, how, and those of us who are on the outside can, if you want our opinions or thoughts, we're happy to provide them. But that's your job. Your job is to come to the people you represent to take issues and to try to fix what may need to be fixed and what needs to be improved upon. There's always a need, and there's always, this committee wants to look at these statutes and make policy decisions or make changes to them. That is certainly your purview and certainly your right to do.
But I mean, I think we should be able to agree that as the statutes drawn now, if you take sexual battery as an example, if there's an unwanted touch to a woman's groin area by, again, some person she knows or doesn't know, but it's clearly an unwanted touch to her groin area, that's a sexual battery, okay? And we've defined, because it's a touch to the groin area versus a touch to her back or her head or her arm, it's different than a simple battery. Whether it's intended to be mean or whether it's intended to be sexual. I mean, there are cases I can think about. There were very prominent national cases where people were sodomized with a object as a sadistic act of torture, not an act of a sexual nature, as one thinks about sexual acts. So, and there's harsh crimes for that, but it would be an aggravated sodomy here. But I think I think we're going to have to go back and restudy Williams and Watson as members of the subcommittee and really bear down on what we have a need to fix as a result of that case. I was not of a mind that we needed to add this extra element in. That may be a policy objective of some. It may even be a valid policy objective of some. But in my understanding of this, when you think about what I've described as a sexual battery, an unwelcomed, clear touch to someone, to a woman's groin area, without our consent, that's a sexual battery because of the nature of where the touch happened. That there's not this gratification element or even a quote sexual nature. So, and to depart from that, to add an extra element is a clear policy departure. It is a different crime, or we've changed the nature of it by adding that element. That is not an insignificant tweak. I think we all agree with that. So I understand it's not the author's purpose to make that change in this bill. That could be another bill that someone brings, or if it is the author's objective, but he missed it, we can include that in this bill. Or if the author can be persuaded that's a policy objective he had not thought about but wants to include, we can consider that. I'm of a mind that the author's intention coming into this is addressing this consent issue. I don't know that this bill addresses it completely because some of the things that were raised, I think we need to talk about some more. But I want to make sure we're at least clear. And I do think, and I would ask PAC to help us understand what the interaction of this without consent element that's got to be proven by the prosecution, how that interacts with it shall not be a defense. I think we all need to be clear about that. And I don't think it's going to, and this is not a legislative Friday. I'm not trying to get us out of here. We can spend more time today, but I don't think it's going to be resolved in this committee today, given the uncertainty we've got.
I agree. The analogy I would use is the justification defense, and how that a immunity hearing can be held and a defendant can be found by a trial judge to not have been justified to use deadly force in a case, but still be able to, at trial, argue to a jury that they did it lawful, that their actions were justified, and to in the process of being able to ask for the jury to find them not guilty of the charges laid against them. That's, that was the part of the discussion I was having, is that while you may not be able to raise the affirmative defense of consent based on this, there is still nothing that prevents, and Georgia has very strong standards that if it is the sole defense of a defendant, they can still argue that. They're not prescribed from doing that. So I can't, I confess, I'm not at the point at this moment to be able to give you examples and be able to provide the information I think that you need to get there. I'm happy to work with anyone who need to be able to be a resource.
Sure. To the author, do you understand that distinction we're working through? And I think I think we're closer than we were at the beginning of the committee, but I don't know that we're there yet.
Yeah, I know it's Thursday in the afternoon, is late, and I'm just going to address and I know the chairman was speaking in generalities in terms of what I personally would be open
what your
to
intentions are with the bill,
modifying this bill. I want to make it very clear because frankly, I wouldn't want to go back home and face a constituent and having this alluded. I'm no way open to making the aggravated battery, the elements of aggravated battery, adding to it to make it more difficult for the public to charge perpetrators like this step-grandfather with the nature of the case. If there's other solutions, that's fine. But in terms of my part in this, that's not a policy perspective. I'm here up here to do. But I understand the committee's still looking at this, and I understand its prudency in making sure we do what we intend to. So,
Chair recognizes Representative Smith for a question.
Mr. Smith,
Stand by if you would.
thank you, Mr. Chairman. Mr. Smith, I think more I've thought about it today, I think I see where if we changed it and described it as sexual, you're afraid about the discretion that would be taken away from y'all as prosecutors. Is that part of,
that's one of the questions. And that's also something that was echoed by the representatives from Gactyl as to who sits and is the arbiter of that. But yes, sir.
Right. And as far as innocent conduct, if we were to find a way to, define this innocent conduct, are you afraid about that taking away prosecutorial discretion?
I'd have to look at the language. I don't know. Dan, I don't think in some instances I could see there it wouldn't be a problem. In other instances, I would, it would depend. And I know that's a lawyer answer, but that's the best answer I can give you.
Yeah, and fair enough. I just those are two questions I had in my mind because these are evil, heinous acts. that occur, and we all hate them, detest them, absolutely. And what I don't want to do is, I do still have faith. There are great prosecutors in this state. There's some that are not so great, but the great outweigh the not so great. So I don't want to make y'all's job harder. And I just want to kind of throw that out there before we ended today, whenever.
And I would say to Representative Smith, without even opining on the greatness or ungreatness of the prosecutors in our circuits, it does fall back to us to write good, coherent law, and without even addressing that issue, so that that judges, prosecutors, defense attorneys, citizens who want to understand, is what I'm doing illegal or not legal, legal or not legal. There's some level of clarity. Representative McLaurin.
Yeah, actually, just wanted to thank you, Mr. Chairman, because I agree with your framing for moving forward. I think that it's a question of figuring out first and foremost what this proposed language actually does to the issue of consent at trial and the proof issues. And if we can determine that, I think it would be easier to have a discussion moving forward. I mean, I think a lot of the concerns I'm raising today and I've heard echoed are relating to what happens if consent is no longer an issue that the defendant can bring into question. Now, the public policy judgment, which I've gone on record today saying I agree with, is it's probably bad to litigate consent under a certain age because there are real issues with that. But and rather than thinking of us as narrowing the scope of these statutes by adding a new requirement, I think we need to be thinking of it differently. If we take the consent feature out of these crimes, we're expanding the liability under these statutes, and we need something to bring it back down to the size that it originally was. So to the author, I don't think any of my comments or Gackel's comments are meant to reduce the number of cases that are prosecutable under these statutes. I think the idea is that if you're going to try to take away one guardrail that defines the scope of the statute, you're going to have to replace it with something else, or else you're expanding the liability to a point that I think we would find unacceptable. So respectfully, Mr. Chairman, I don't think this bill is amenable to a piecemeal approach where the author's attention can be handled separately, just deal with consent in one bill and then figure something else out later. To me, it seems like we're going to have to figure out whether it's a sexual nature or whatever. And to the attorney's point who testified, the word sexual appears in the sodomy statute already. It's a sexual act. And Mr. Smith, respectfully, I think Gackel's, point about the word sexual appearing and who decides is only when you make it specific to the defense. The affirmative, you build that into the no defense language, then you have the judge deciding. But making it a factual issue for the jury to decide is not something the General Assembly has had a problem with in the past. So I think, that's, to me, we've got to build our guardrail into the legislation if we're going to take the guardrail, a different guardrail away. That's my final comment on it.
Sure. And once Representative Smith speaks, it may not be your final comment. I'm not going to constrain you to that. I would say today our goal is to understand the issues, kind of frame the contours of the debate, and understand what ideas are on the table. I'm going to recognize Representative Smith here in a moment. Is there anything else, though? We've got Mr. Brody and Ms. Causey. Is there anything else that the representatives from Gackel want to speak to before we move on and kind of wrap up with final committee testimony?
Chairman, I would just say, just as usual, we are willing to work with the author and PAC to try to work through this. I think the issues that have been raised today are the issues that are, the ones that need to be addressed before we can have some sense that not only the sponsor's goal is being met, but that the law is clear on what's a crime and what's not a crime and who's culpable and who's not. I guess I would like for the committee to understand, with respect to the Williams case, oftentimes the Supreme Court of Georgia does kind of reach out to the legislature through their opinions and solicits your assistance, essentially. That's really not the case in this particular opinion. I think if you read through it, you'll see, like I said when I started, nothing about this consent issue prevented Mr. Williams' conviction from being upheld. This is not a situation where the court was opining some gap in the law. That's just not where we are. But we are here, and it is a viable issue that we need to work out, and we are more than willing to do that, and we'll make ourselves available as needed.
As always, thank you, Ms. Causey. Chair recognizes Representative Smith for a question.
I think if there's a way that you can define this innocent conduct somehow without taking away from prosecutorial discretion, because I do want to make it clear. I can see where if you added the word sexual in describing this, how that could take away prosecutorial discretion with, especially with the broomstick example that Chairman Setzler had provided earlier for us. If there's a way to do that, I think it's worth looking into. But if it is going to limit prosecutorial discretion, then I don't know that I'd amend your bill as, I think as is may be a better way to proceed, but still just, I would like for y'all to look into that a little bit if we could, because here's what I don't want to see. I don't want to see an innocent actor have to go through the criminal justice process and have to wait for us to get through with appeals and figure out what the fix is. That's where I'm coming from. I don't want somebody that's innocent that falls into these innocent conduct situations, even though we as enlightened individuals in this committee room today and online, we could see that these situations wouldn't be prosecuted. I still, if we can limit that from happening by statute without having to go through that process I just mentioned, I'd be a lot more comfortable with it if we can do that.
Thank you, Representative Smith. To the author, any last words for the committee? So again, I appreciate everybody's time going through this today. I want to make sure that certainly it's the committee's prerogative, subcommittee's prerogative. If they want to add some things to a bill that's moving through the process, it's not the sole discretion of the author who proposed the bill. So I'm not trying to insinuate that, but I do think we need to have clarity between this, clarifying this consent question throughout Chapter 6, Title 16, and this issue of are we well advised to add a sexual nature component to sexual battery or aggravated sexual battery when the child molestation statute has something similar to that. It's a policy question. So let's explore those questions, and we'll reconvene next week after the author has some time to talk to members of the subcommittee and make sure we've got clarity moving forward of how we would step with confidence. So with that, we stand adjourned.